For those who don't read the community posts, boy, are you in for a treat. For those who do, you probably already know that the SCOTUS petition has been filed, just as I predicted it would. And yes, I read 149 pages of it, so it's real. It basically asks two main questions. The first one is whether a final and unanimous but unannounced decision by a jury following trial that the prosecution failed to prove a defendant guilty of a charged offence constitutes an acquittal, precluding retrial under double jeopardy clause. And 2, whether a defendant who produces credible evidence of such a final, unanimous and unannounced acquittal is entitled to a post-trial hearing to substantiate the fact of such acquittal. There's important distinctions about the way these two questions are being posed because now it's SCOTUS. But essentially, it's still addressing the main cause that just went through the SJC and then up to the habeas and now to SCOTUS. As we all know, that is manifest necessity. Now, some of you are asking a couple of questions. Firstly, can they broaden the scope to include all of the other misconduct? And secondly, what are the chances? Are they zero, as some negative Nancys might suggest? So let's start there. Zero chance. Now, some of you might have your thinking caps on and understand implicitly that 0 is actually smaller than 1%. It's also smaller than 2%. It's smaller than anything larger than 0, in fact. So, if you're calling it a lost cause before it even gets off the ground, then you're probably not understanding the math. And you all know how I love math, so we're going to learn some math today. Before we kick off, I'm going to shorten writ of certiorari down to cert, because my mouth doesn't like saying it over and over again. SCOTUS receives around about 7,000 to 8,000 certs per year. So when people say only 1 to 2% of SCOTUS petitions are granted, they're usually quoting that rate out of all petitions filed, roughly 7,000 to 8,000 per year, or per term if you prefer. To show you how this all works, I'm just going to pick a number right in the middle so we can work off that number rather than a range. So I'm going to go with 7,500. Let's assume at this point in time, when Karen has filed her cert to SCOTUS, there's 7,500 others also filed. What you may not know, and what many probably won't mention, is that around 90% of those filings are pro se. That means the defendant is representing themselves. In a good year, you might see one pro se cert granted by SCOTUS, but most times it's 0. So if you were talking strictly pro se, then 0% chance is probably pretty accurate. What we do know is that Karen is represented by some pretty hardcore skilled appellate attorneys. And that puts her squarely in the approximately 10% range of certs that SCOTUS might consider. For the sake of the exercise, we're going to say it's 1,000 certs per year that are clearly represented by a qualified appellate attorney. Now, let's break that down into the key criteria that SCOTUS grants each year. The stats tell us that around 60% of granted certs, we're not talking about rulings here, we're just talking about granted, which means SCOTUS agrees to hear it, but there's no guarantee they'll rule in your favour. We'll come back to that. Of these 1,000 petitions filed by experienced appellate counsel like Weinberg and Alessi, raising constitutional questions already identified in SCOTUS precedent represents about 60% of granted petitions. Those with a strong factual record, like in this case jury statements, around 30% of those will be granted a hearing. Of those two groups, only about 15% have amicus support. You may have heard this term before, especially in relation to the buffer zone. The full term is amicus curiae, if you've got one, or amici curiae, if you have more than one. It basically means friend or friends of the court. These filings are generally referred to as amicus briefs. An amici support basically means that third parties, individuals, organisations, legal experts, are urging the court to grant cert or rule in a certain way. The reason this is important in Karen's case is because the current cert is limited in scope to precisely the topic and scope that the SJC, and then that was appealed up to the habeas court, and then that was appealed up to SCOTUS, being the manifest necessity scope. That means that all the other things going on are off limits. However, amici curiae, or friends of the court, they may be able to bring in some of the other issues, so long as it ties back to double jeopardy and or the Fifth Amendment. I have a feeling I've got an idea what that specific topic could be that ties back to the Fifth Amendment. But for now, let's continue with Karen Reid's chances of first of all being granted, and then we'll look at her chances of success. So we've broken it down to clear constitutional questions with a strong factual record have a very good success rate of being granted. The US Supreme Court Rules and Guidance acknowledges the presence of amicus briefs at the petition stage is associated with a higher likelihood of certiorari being granted. The data shows us that petitions with one or more amicus briefs are 4 to 8 times more likely to be granted. Amicus briefs matter because they can 1. Highlight public or constitutional importance, 2. Show national or legal community concern, 3. Clarify the real-world impact of the legal question, 4. Point to unresolved conflicts or circuit splits, and 5. Signal credibility. So in Karen's case, amicus would be incredibly important where there are circuit conflicts, systemic concerns about judicial and prosecutorial entanglement, we'll get to that later, a compelling factual record, and likely amici from multiple jurisdictions and disciplines all add tremendous weight to the cert petition. So assume for 1 minute we do have amicus support, and they are somehow going to tie this other misconduct back to the Fifth Amendment issue. So let's break down the key criteria into some core issues or categories. In a typical term, SCOTUS will grant around 20 petitions on circuit splits. That's when, say, the First Circuit doesn't agree with the Seventh and others, or something along those lines. What we do know from the 150-page cert is that there is a split between the First Circuit and the Seventh Circuit and others on manifest necessity and whether it violates the double jeopardy clause. I've marked this one in green because A, it is being raised in the petition, and B, it's one of the most granted issues that SCOTUS will hear. They would typically grant 15 constitutional criminal procedure issues. These would include due process violations, structural bias, denial of the Sixth Amendment and fair trial, for example. They would typically grant around 12 petitions concerning federal statutory interpretation. This is like Rule 17 abuse or misapplication of court rules. They would typically grant 8 petitions for First Amendment issues. Death penalty isn't applicable here, but they would normally be around 8 of those per term. And around 6 qualified immunity or police misconduct, official misconduct. 5 admin law or Chevron deference, not applicable here. Commercial clause or federalism, not applicable here. Immigration or deportation, 3, not applicable here. Election law and redistricting, 2, and not applicable here. And finally, civil rights, or the 14th Amendment. They would typically grant at least 2 of those per term. All of these numbers are specifically petitions granted with amicus briefs. So for example, in the circuit split category, this 25 is the average granted in a typical period. But generally only about 20 of those come with an amicus brief, and that's what we're looking at specifically. Those with amicus briefs that have been granted. Not necessarily ruled in favour of. We'll come back to that. So when it comes to Karen's chances of being granted, expressed as a percentage, we would say she has 1 in 20 chances based on circuit split category. That equates to 5%. She has 1 in 15 chances in the constitutional criminal procedure. That comes to 6.7%. These are considerably higher odds than 0 or 1 to 2%. Once you add amicus briefs into it, which I'll show in orange here, the chances are considerably more. For example, federal statutory interpretation, 1 in 12 chances is 8.3%. First Amendment issues, 1 in 8 chances, that's 12.5%. Misconduct issues, 16.5%. And civil rights / 14th Amendment issues is a whopping great 50% chance that SCOTUS will consider those issues. So let's break it down again even more into most common to more rare situations. As we established in the first chart, circuit split is the most common reason SCOTUS steps in. Out of approximately 25 annual submissions that they might consider, 80% of them would be granted. The double jeopardy issue falls under recurring constitutional issues, and out of the 15 that they might consider for the year, 80% of those might get granted. In the exceptional importance and public interest category, nearly all of them get granted. Under due process violations, of the 10 they may consider, 80% of those will generally be granted. Under judicial misconduct and structural bias, these are fairly rare, so they might only consider 5 of those per year, but they are pretty serious, so generally about 80% of those will be granted. Under state and federal conflict, not quite as serious as judicial misconduct, but of around 5 of those that they'll consider, 80% of them will be granted. Unusual or irregular conflicts of interest. These are the rarest, but because they're the most powerful category, 100% of them are granted. Again, 100% of each category is supported with an amicus brief. And these categories that we're homing in on here are specific to Karen's case. The first 2 are specific to manifest necessity and double jeopardy. The rest are issues that an amicus brief could introduce and support, so long as it ties back to due process and double jeopardy. Again, the amicus brief would have to be narrowly tailored, but you have a little bit more room to introduce things in the footnotes. So you might start with the very limited tailoring addressing structural entanglement. Like, for example, Schillinger representing the trial court at the SJC and the habeas court. That would be an example of structural entanglement. And it violates the supremacy clause, so that brings in state or federal conflict. It's also an unusual conflict of interest. An even more serious example of that would be looking at this petition's filing. We see a notice of appearance by John R. Hitt on behalf of Trial Court of the Commonwealth of Massachusetts Beverly J. Cannoni and Jeffrey Noble, the new police colonel, and Michael Morrissey. You might normally see someone like the police colonel represented by his own attorney because he has custody of the defendant. But you don't often see the DA's office tied to the trial court under the same attorney representing both. This is a structural entanglement that blurs judicial neutrality. So an amicus brief might address this specific issue. But then you could bring in things like Michael Morrissey's emails to other judges influencing their decisions in associated cases, as a footnote, for example. Or Canoni messing with the jury forms is another example. Appointing Fanning to the court security is another example. They all could tie into this structural entanglement, which also ties back to the original due process tailoring of the original petition. So let's assume that we have the main petition addressing the circuit split concerning manifest necessity, and then we have the recurring constitutional issue of double jeopardy, i.e. due process, and we have the Supreme Court's own documentation saying that there's a much higher success rate if you have a good, strong amici support. So what's the success rate of getting a ruling in your favour once you've got to this stage? Of the 20 amici supported petitions that might be granted each term, around 60% of circuit splits or unsettled law are ruled favourably. Around 70% of double jeopardy grants are ruled favourably. Around 60% of recurring constitutional issues are ruled favourably. 65% of exceptional public importance are ruled favourably. 55% of due process violations. 50% of judicial misconduct or bias. And 55% of state or federal conflicts. And the key issue that your amici would be focusing on is the 45% of unusual conflicts of interest that are ruled favourably. So, what you'll notice is, from the get-go, once we ruled out pro se, the odds dramatically increased. Then we added the amicus brief. The odds of being granted are considerably more than 1 or 2%. And once you're granted on one of these main issues, the odds of them ruling in Karen's favour are somewhere between 45 and 60%. As it stands right now, before they've even looked at it, Karen's petition has a 10 to 12% chance of being looked at, specifically because she has experienced appellate attorneys looking at all of these figures that we just looked at and working out which ones are the strongest. While Karen and the team work on that, what we need to do right now is lobby some amici and encourage them to submit an amicus brief. And I don't know about you guys, but I think Mark Betterow is very well positioned to lead the amicus brief. And so in the next video, I'm going to break down some possible topics, who I think would be great candidates for amici, and why I think they're good candidates. So hang in there, part 2 is on its way.